Hi, everyone. So now we're going to talk about the limited scope representation programs and best practices in those programs. So our speakers are Yacine Barry. She is the director of the Housing Court Initiatives for the Access to Justice program. Antonelli is an attorney with Paul Hastings, and their firm is very active in the Housing Volunteer Lawyer for the Day program. Daphne Schlick is the director of the Consumer Protection Program at NILAG. And Sidney Cherubin is the Director of Legal Services for the Brooklyn Bar Association Volunteer Lawyer Program. So I'm going to start with Sidney to talk a little bit about the Brooklyn Bar Association Volunteer Lawyer Program and how it partners with the court.
Good afternoon. I'm the Director of Legal Services at the Brooklyn Volunteer Lawyers Project, as Lori mentioned. And the Volunteer Lawyers Project has been partnering with the court since 2009 to coordinate the Volunteer Lawyer for the Day Consumer Credit Project. And so the program started logically, well, as Mark mentioned earlier, we started the Claro program in 2006 in Brooklyn. And one of the things that I think the students were looking to do, and as well as the volunteer attorneys who were providing advice and counsel to the people at the clinic, was to see these cases to the next step. And logically, the next step would be to go into court and represent them. And so in 2009, when the court approached us about starting this program, we were very happy to come on board and start doing that. And so just to get a sense, since these are our numbers from 2011, we've represented people in approximately 3,200 cases with suits amount close to $17 million, and having these cases either settled or dismissed or discontinued at for about $10 million. So we've seen settlements or results at about 57% of the suit amount. These cases are either discontinued, settled, most of the times at 50% of the suit amount. Very rarely do they go to trial. Every now and then they go to trial, and when they do go to trial, we prep a client for trial if necessary, and on occasion, if I'm so moved, I might take it on through the VLP to handle the trial myself. And so we have trainings that we provide for our volunteers. Most of the trainings happen through the Bridge the Gap program here with the courts, which happens twice a year. It consists of a 5-hour training, 3 hours of basic consumer law. So my Claro training that we do on a regular basis citywide, we'll do here at the court twice a year, once in the spring and once in the fall. And in addition to that, there's a Volunteer Lawyer for the Day component to that, which is an additional 2-hour training, which trains our volunteers on what to expect in court, what to do in court, how to deal with clients when you're in court. One of the strengths, I think, of the program is I think we've, even for the people that we're just seeing at Claro, we're providing them with tools to go in and represent themselves. Even prior to the Volunteer Lawyer for the Day program, we were starting to see a change, different results in these types of consumer debt cases in terms of settlements and cases being discontinued. When we started doing them, these cases would go on for years and years, adjournment after adjournment, until eventually someone broke. Either the plaintiff decided to discontinue the action or the defendant decided to enter into a settlement. And with the creation of these programs, we're seeing resolutions at a much faster rate. In Kings counties in particular, most cases settle within 2 to 3 visits. Or have a resolution, not necessarily settlement, but some sort of resolution within 2 to 3 visits. So the strength is that we're getting better results for litigants. Litigants are becoming, they're educating themselves a lot more. They're using the internet. they're coming and they're seeing me and they're telling me what the law is. And so that's a good thing, sometimes a very annoying thing, but it's a good thing that litigants can come in and they've done their research and they'll say, I don't know who this person is that's suing me, but what I saw online is I should be asking whether or not they bought the debt and do they have some sort of affidavit and whatnot. So programs like this help. We can't represent every single person in court. In Brooklyn, there's probably 100 cases on the calendar. We handle maybe 10 a day. Just because we are limited by our resources, our coordinator is only one person. They're supervising 4 or 5 different people. And so what we try to do is, in addition to providing the direct representation in court, also providing them with the information so that if they're not represented, that they know what to do. They can watch us in court. I don't care if someone eavesdrops on my conversations and just in terms of legal defenses and procedure. And if they want to go and use those same arguments with the judge, it's fine by me. Or people coming up to me in the hallway and asking questions. Our program is a little different. I don't want to speak too long, but I also coordinate the Claro project and the Volunteer Lawyer for the Day project. So my hand is in everything. So if I meet someone in court who's unrepresented one day, I can send them to my clinic on Thursday night and say, come see me. I'll help you out here, and if I can give you an attorney for your next court date, we will. So basically, that's how we got involved in 2009. It was the perfect transition from Claro to get people into the courtroom. It's provided a lot of legal experience for young and new attorneys, and new attorneys have learned skills that you don't learn in law school. I learned a lot in court. I learned nothing in law school. I can tell you right now. Everything I've learned has been through practice. And this program is both beneficial to new attorneys, old attorneys, and to litigants that we represent.
So it's the end of the day. Everybody's tired, and Sidney just said basically everything I wanted to say. So I hope you'll be patient. But I'm with NILAG, and NILAG started the Consumer Credit Project, Volunteer Lawyer for a Day, in 2010 in the Bronx. We were invited to be a partner with the Access to Justice project back then. And I guess we did okay because then we were invited to participate in the Volunteer Lawyer for a Day in Queens, and we began that project in 2011. I'm sure you're probably familiar, but just in case you're not, both of those programs for the Volunteer Lawyer for a Day run Monday through Thursday mornings. Friday is the only day that we're not there. I think it's the same in Brooklyn. And I'm actually really excited to be here, and thank you for inviting me to the panel because I don't get to speak a lot about this. Of course, again, we're last, and a lot of people said the things I wanted to say, but still, I'm here. And it's a really wonderful program. It is an incredibly impactful program. In a very short amount of time, you can have a huge impact on a lot of people who, as you've heard all day long, otherwise would absolutely not get representation. But it's more than that because they wouldn't only not get representation, they wouldn't understand their rights. And we've had, today we've had a lot of intellectual discourse about what are the benefits, what are the downsides. But when we started in the Bronx in 2010, we're just talking very basic legal rights in that a lot of the defendants that appeared in the Bronx Civil Court, they thought that the plaintiffs were court personnel. So even something as simple as having a volunteer lawyer that is explaining to people what the different players are in the courtroom, I think everybody in this room probably takes that for granted, but to a defendant who has never appeared in court, they are scared, they are on good behavior, they may not, in many cases, even understand why they're there or why they're being sued or recognize the debt or recognize the plaintiff, and the only experience they've had with court is watching television. That alone, just explaining the players in court, what their rights are, what's going to happen next, that has had a huge impact, I think, on the consumer landscape. And I did also have some fancy numbers that sounded a lot better before that statistic about pets and Halloween costumes. But anyway, in the Bronx, we have saved consumers just in the Bronx since the inception of the program in 2010 about $6 million. That represents cases that were dismissed, that the plaintiff did not have a right to pursue, or amounts that were reduced because the defendants exercised their rights. In Queens, we saved defendants $3 million. And I forgot to mention, in Staten Island, I don't know if anybody invited us to start Staten Island Volunteer Lawyer for a Day officially, but we are now staffing Staten Island as well. And so we do that twice a week. We're going to be starting twice a week. That's our newest program. And we just started that in October of last year. And already we've saved $200,000 for defendants in those cases. I think those are definitely not more than pet Halloween costumes or whatever that statistic was, but I think it's impressive. In terms of numbers served, we've also served in the Bronx since 2010. Just to give you an idea, when I say high impact, what does that mean? That means we've served almost 6,000 cases. We've handled 6,000 cases since 2010. In Queens, the number is 2,000, and in Staten Island, again, just being a program that's 1 year old, it's almost 300 cases. So I think I'm not very good with numbers, but the director of General Legal Services at NILAG is, and he came up with an impressive statistic that was something like for each case that the Volunteer Lawyer for a Day serves, and I think this is consortium-wide, meaning all of the boroughs, because we apply for our funding and we operate as a consortium, the cost for one case is $97. So you can see the high impact there. If you hired a private attorney to take that case, it clearly would not be $97 for the kind of outcomes that we reach. And in general, we reach favorable outcomes, as Sidney mentioned, which includes dismissal, discontinuance, even something as simple as requesting evidence, which often doesn't happen unless somebody is represented. We can resolve those. We can resolve cases in that manner 80% of the time, just on the first appearance. I think also, and I don't know, do you want me to just pass it on or just keep going? Okay. In terms of other ways that I have seen sort of a general impact of this program, of the Volunteer Lawyer for a Day and Consumer Credit, so I think that when we started, there was definitely, and I'm just going to say it, there was definitely a stigma against consumers, and I think a lot of people assume that if they're here appearing in court defending themselves on a debt, there was a stigma against them. They were deadbeats, they charged some items and they don't want to pay for it. And I think that one thing that, again, we take for granted in 2015 is that we have really come far in understanding that that is not at all the case, that what is happening is, it's been reported in the New York Times and in a lot of media that there are unethical practices on the plaintiff side, debt buyers. And what was happening was there were cases of identity theft. There are many cases that are pursued past the statute of limitations, which is not allowed. We have a problem with false affidavits. All these things are well known now, but when we started in 2010 and 2009 for you, that wasn't the landscape. That wasn't that well known. And I think that the program has really brought to light a lot of these problems, which again emphasizes the need for these defendants to be represented. And in many cases, the Volunteer Lawyers for a Day really are the only hope that these defendants are going to have to understand their rights and be able to assert the proper defenses. They don't assert them, they're done. They can't assert them later. It's too late, as we all know. I think another testament to the program, which is interesting, is that a lot of the plaintiffs' attorneys, when the cases are adjourned, they really push to get the cases adjourned to Friday. That's the one day we're not there. I think that speaks for itself as well. And lastly, I'll just point out that many, many times, if a volunteer lawyer for a day appears on a case, and this just happened, one of our staff attorneys that's sitting in the audience just told me about this, it happened twice yesterday. Just the mere appearance of an attorney on the defendant's side can get the case discontinued. Very often the plaintiffs will recognize that they don't have the proof, as you've heard here today, and they'll just discontinue the case. That would not happen if that defendant was not represented for the day.
Good afternoon, everybody. My name is Yacine Barry-Wun, and I'm Special Counsel for Housing Court Initiatives. Can you hear me? Yep, okay. I work for Justice Fern Fisher in the New York State Courts Access to Justice program, and one of the initiatives I run is the Volunteer Lawyer for the Day program for the Housing Court, which I'm here to speak about today. And that program helps prevent the eviction of hundreds of New Yorkers every year who live in rent-stabilized apartments and who are being sued for non-payment of rent. Thanks to the pro bono help of the volunteers we recruit and train and supervise. And that program was launched back in 2006 as a pilot project. Thanks to a collaboration of the Civil Court, the Deputy Chief Administrative Judge for Justice Initiatives, the New York City Bar Association, as well as Fordham Law School's Farrick Center. So I tested over a period of 4 months and to check whether unbundled representation actually was an effective means to alleviate unmet legal needs. The Civil Court recruited and trained about 30 lawyers, 21 of which were retained to represent 50 litigants and appear on their behalf for a one-day court appearance. And once it was established that the program benefited not only the litigants but the court system, the rest was history, because we were able to issue a report that basically assessed that there was an improvement in access to justice and perceptions of fairness and accessibility to justice. It also aided in courtroom efficiency and of course, leveled the playing field, which is a big deal. It also provided an attractive pro bono opportunity for the volunteers. So the program started in this building in New York County, and as a pilot project, became a program for a couple of years, continued here in this very borough. And then we were able to expand the program to Kings County as early as 2009, thanks to a collaboration with CUNY Law School's Community Legal Resource Network. And with some additional funding to CUNY, we were able to operate it in Queens part-time, and we also had it in the Bronx for a little while. And currently, we have limited funding, but we're able to operate it in New York County 1 day a week and twice a week in Kings County, which is Brooklyn. Our operating costs are really minimal in that we use court personnel and to recruit, schedule, train, and supervise the volunteers. And by court personnel, that means me. I'm the supervising attorney for the program. And I also work very closely with my assistant, who's wonderful, Aziza Tropea, who provides support to run the initiative. And we couldn't make this happen without the mentorship of the coordinating attorneys we work with. These are typically remunerated by the organizations we partner up with. And these organizations, such as CUNY Law School, receive generous grants from the New York State Judiciary Civil Legal Services Fund, and in the past also from the New York Community Trust. I understand that they've also worked with anonymous donors. So that's how we were able to expand to the second department. And in the past, we were lucky to have a retired judge act as coordinating attorney in the Bronx for a while, so I think it's worth noting. All of our speakers are drawn from a pool of local experts, which include judges, many of whom I see in the audience, and we also have court attorneys and who teach our volunteers, and they therefore require no compensation for travel expenses because they live locally, and they donate their time generously, and we pay them in CLE credits. So mainly the court attorneys and the attorneys who are in private practice who teach for us. So our costs are really limited to providing light refreshments and advertising the trainings through posters, brochures, so on and so forth, and providing office space and basic office supplies in order to run our initiatives. We don't operate as extensively as the other programs you heard about, but in 2014, we trained about 200 volunteers who contributed about 3,650 hours, which is quite notable, and who represented about 250 litigants. Again, we operate on a part-time basis in a couple of boroughs, but we're going to go on to other themes, so I'm going to put it over to Lori.
And Anthony, why does your firm participate in the program?
Sure. Good afternoon, everyone. I'm Anthony Antonelli. I'm a litigator with Paul Hastings, and very excited to be invited to the panel today to just share with you some of the volunteer experience that my firm and also me personally have had with the LFD Housing Court Program. You know, a big part of what we do, a big part of our firm is the commitment to pro bono, and we have, you know, a variety of programs, from everything from, you know, environmental rights and adoption cases, all the way to, you know, constitutional rights. You know, here in New York, a very big part of our pro bono program is the VLFD Housing Court program, and for me personally, it's a favorite, you know, for several reasons, and I think there's a lot of unique aspects to the program that are different from other pro bono activities that we participate in. First and foremost, you know, as with any pro bono initiative, you want to make sure that, you know, you're helping people truly in need of your legal services, and I've seen, you know, firsthand that cannot be more true with the VLFD Housing Court program. You know, these are families who, like Yacine mentioned, are in severe financial distress, in danger of imminent eviction, and, you know, through the program, you're provided with the opportunity to help them at that moment in time. Also, these clients are really, you know, when you meet them, you can see they're unable to represent themselves in these proceedings. I mean, for a lot of them, you know, English can be a second language, which, you know, poses communication difficulties with the landlord and then, you know, appearing that day in court. And they also just don't have a basic understanding as to their rights, as to how the process works. So through the program, you know, the program allows you the opportunity to hop into the representation at the time when they need it most, when they're appearing that day in court before a judge, and otherwise would be somewhat powerless in the system. And for me personally, I know from others who participate in the program, it's truly, you know, a rewarding experience knowing that you have the opportunity to make an immediate impact. And that's one of the differences. I mean, just with other pro bono programs, or myself as a litigator, I'm on things that, you know, take years before from the time you start to the end point where you can, you know, maybe get a great result for your client. And I think the VLFD program is very unique in that sense, where you can get there in the morning and, you know, provide representation and hopefully get a great result for your client, you know, by lunch. So it's very unique and very exciting in that way. You know, I think, to go to your question about from a firm perspective and why we participate, I mean, that's number one. a corollary to that is, you know, aside from providing these services to the people who need it most, there are huge benefits on the attorney development side, particularly for junior attorneys. I think, you know, your first year out of law school, there are going to be very limited opportunities for one-on-one client contact, for being the lead attorney appearing in court, for negotiating a settlement with opposing counsel. Again, these are things that the VLFD program provides to attorneys at a very junior level who might not otherwise have that opportunity until they further along in their career. I've been there before, and you know, a typical day when you get there, you receive your case file from the supervising attorney, you go over it, and you're off and running. From that moment on, you're going to meet immediately with the client, go over the representation, explain the limitations, understand the issues that they're facing, understand, you know, what a potential resolution might look like. After your client meeting, you're then negotiating with the landlord's counsel. And, you know, to be a first-year attorney, to lead that negotiation is something that you might not otherwise have on your other matters. And if you can reach a settlement, you're then documenting that settlement and then appearing before the judge, you know, as the lead attorney representing your client, which, again, is all great experience, especially for junior attorneys. And then I think just for last, and I know we're going to touch on this later, so I won't spend too much time on it, but another unique aspect of the program is truly the training and the supervision, and it really is two distinct things. First, you know, it's a robust training that's provided to all the attorneys who want to participate. And again, these are, you know, from our firm, they're attorneys across all levels, from first-year attorneys all the way through partners, and they're attorneys across all practice areas. So even though you're in court, this is not limited to just litigators. So you have, you know, corporate attorneys who might not otherwise have any reason to go to a courtroom but for this program. And I think the VLFD program does an outstanding job with training all kinds of attorneys to prepare them to appear in court, and then once you're in court, providing the supervision that you need and the guidance. So I know we're going to touch on that later, but you know, those are some of the, I think, the things that make this program, you know, very unique and worthwhile.
Thank you, Anthony. Yacine, you mentioned that the program does non-payment cases. Why are these cases appropriate for limited representation? Why was that aspect of housing cases chosen?
Most of the non-payment cases get actually resolved, and we in the program focus on legally and factually simple cases. So we focus on more straightforward types of cases. And I would say also that landlord-tenant proceedings are quite appropriate or ideal for the lawyer for the day approach, in that there's no discovery as of right, and the issues are more simple, so the volunteer can actually get acquainted with the court file pretty fast and interview the client based on the intake form that was previously prepared and the answer form that was filed by the program, and get the client ready quite quickly to get the negotiation started and execute any stipulation of settlement. We focus on rent-stabilized apartments. There are some exclusions. For instance, we don't do Section 8 cases. We don't handle non-payment proceedings involving rent-stabilized apartments where the apartment is in a co-op or a condo. That would go to a different part. And one of the reasons why we take on rent-stabilized cases is because it's really the last frontier for affordable housing in New York City. So I think that's where we can have an impact. And you know, non-payment proceedings represent quite a large volume of cases. It's the largest volume of filings in housing court. It's also it presents a situation where in more cases than not, in more than 95% of cases, the tenant is unrepresented and their adversary has counsel, so it's not a level playing field. Basically, a lot of the tenants, unfortunately, don't understand what rights or defenses they may have, what options they have, and they're also inexperienced at negotiating. It's an environment that's quite adversarial. A lot of the negotiations actually take place in the hallways where it's loud, people are emotional. There's a lot going on in their lives. If they're in housing court, it's because they're running out of money, they're afraid to lose their home, they probably have consumer debt on top of it and other issues. So they have a lot going on in their personal lives, and we're there to alleviate their stress, educate them as far as what options they have, and get them more favorable outcomes.
I know that earlier we mentioned screening and intake, that it was really important how you screen these cases. So Yacine, how are these cases screened for the housing program?
So unlike legal aid or legal services organizations, our court-sponsored program does not income screen. We just check that the...
Who does the screening?
So who does the screening is the volunteers and the coordinating attorneys. The screening is done in the clerk's office where we pick up cases. So we literally approach people who are standing in line in the clerk's office who are there to file their answer. And we check that they fit the requirements of the program, that they're here for the first time to file their answer, that they don't have an ongoing case, that they are indeed being sued for non-payment of rent, that they live in a rent-stabilized apartment, and that they don't live in a co-op or a condo or don't have Section 8. So those are the main requirements. And we pull them off the line, we get their court file, and we conduct the interview based on the detailed intake form. And we inquire into possible factual defenses or counterclaims. We actually help them fill out the answer and explain to them what documents they should bring back to court the following week for their first court appearance. And we get them to come in earlier than when they're scheduled to check into court so that we can meet again with them, review the documents that they brought with them, and further assess their situation. We oftentimes give them instructions as to what to do between the time they answer and the time they come into court for their first appearance. Sometimes if we suspect that the rent is not legal, that there may be an overcharge, we direct them to go to DHCR and get a rent history so that we can analyze it and review whether the increases that they were subject to were legal. We also, if they need help in paying their rent arrears, we direct them to the Department of Social Services and charities so that they can file an application to get things rolling and possibly access monies to pay their rent arrears. There's a big social work aspect, if you will, to what we do in housing court. So we try to approach the whole process in a holistic fashion. Sometimes there are legal defenses. Sometimes the legal defenses may be weak, but we try to help the litigants connect with financial resources if that's what they need to resolve their case the best way possible.
Thank you, Yacine. Sidney and Daphne, for your program, how are cases screened and referred to the Volunteer Lawyer for the Day program? I know, Sidney, you mentioned Claro in Brooklyn. Is it the same for for Queens, it's also Claro?
Yeah, the majority of our referrals do come through the Claro project. Since I'm there, I'm screening anyway, and there are no income guidelines. Generally, it has to be a consumer debt matter. I tend to stay away from Con Ed and any other scary car insurance cases and stuff like that. But we will do credit cards, student loans, auto deficiency cases. On occasion, we'll do breach of lease cases. Excuse me? Medical debt is another big one. As the program has evolved, the issues that we're seeing more and more at the programs are changing. When we first started, it was strictly credit cards. And then all of a sudden, there was a period where we saw a lot of auto deficiency. And then we're starting to see a lot more medical debts. And so as the program evolves, as the issues evolve, the program sort of has to evolve as well. And the beauty is that I'm there and I see the people at Claro. I'm able to provide them with a referral, and our coordinating attorney is also at Claro, so she, on occasion, will get to meet with the client before they come to volunteer lawyer for the day as well. So most of our referrals do come through Claro. On occasion, they do come from the help center. So Eric in Brooklyn will meet with people on days that we're not at Claro and provide them with a referral for volunteer lawyer for the day. And then if we don't have enough clients on a particular day, we might make an announcement prior to the calendar call, just asking people if they're looking for assistance on a consumer credit action. We'll take a look at their either their motion papers or their answers and see what they're being sued for and let them know if we can help them on that day.
Yeah, I think that's pretty much the same for Queens, the Bronx, and Staten Island. We also get, since we're a legal services agency, we have a general intake line, like most agencies, and we get a lot of calls. I don't know why I'm leaning over, like this doesn't move. We get a lot of calls from random people calling, and the calls for consumer debt get transferred to our project, and that way we can refer them all to volunteer lawyer for a day. I think in all of the boroughs, my staff, please correct me if I'm wrong, the judge or the clerk or the staff, the coordinating attorney themselves make the announcement, and we do tend to get swamped that way by making the announcement in the morning to let people know that we're available and there are free services. And also, obviously, from other units internally within NILAG, so our family law unit, our immigration unit, if they have clients that have consumer debt, they talk to us, and then we can refer them to the appropriate volunteer lawyer for a day.
Something that you touched that I didn't mention, the judges in Kings County are very receptive to the program, and they refer clients to us as well. So we have one judge in the personal appearance part in Kings County, and rotating judges in the motions part, but they have our flyer for Claro, because they know litigants can go there to get a referral for volunteer lawyer for the day. So if they have a litigant in front of them that looks like they need help, they will refer them to our project for legal assistance. And then, of course, word of mouth from other clients.
Sidney, you mentioned that the issues are constantly evolving. So could you talk about training, because if the issues are constantly evolving, you're constantly evolving your training, I assume, but talk a little bit about the length of the training, what's covered in the training, how does that work, who does the training?
So the basic training is our consumer debt training, which is a 3-hour training. I do it here for the courts twice a year, and as Mark mentioned earlier, citywide, the different organizations host the trainings as well throughout the year. So Mark will do it in the spring, and we do it in the fall in Brooklyn, and the Feerick Center will hold it a couple of different times because they're also in Staten Island. So that training basically gives a new volunteer the basic understanding of consumer debt law and litigating these matters and what issues to look out for. Once a volunteer is trained, they then are invited to come to Claro. I always tell people, in addition to doing work at Volunteer Lawyer for the Day, it's always great to come to Claro, because I always say that we do all the work at Claro, and then you just have to, someone comes in and argues it for you at Volunteer Lawyer for the Day. So it's a whole different program. So at Claro, we're preparing the motions, we're responding to motions for summary judgment, we're filing answers, we're doing the orders to show cause to vacate a default judgment, and then we refer them to Volunteer Lawyer for the Day, and on that day, a different volunteer is helping them argue those motions or litigating the case, because if it's down on the trial calendar. And so it's two different experiences that I always recommend that people do both, just to get the whole picture. But once volunteers train, they shadow an experienced volunteer. And so our coordinating attorney, our current coordinating attorney, did this work in Massachusetts for about 1.5 years. And so she has the basic understanding of consumer debt law. I've been doing it for quite some time. So we're the two people who serve as supervisors at those programs when volunteers come. So your first 2 weeks, you're probably shadowing, you're following me around, or you're following Glenna around, you're seeing how I interact with opposing counsel, you're looking at the arguments that I make, and you're deciphering why I would make this argument in this case and not in that case, and you have an opportunity to ask questions. After that trial period, if you're comfortable, I will have you start meeting with clients individually for intakes. No one does anything without running it by me anyway. All the volunteers, whether they're admitted or not admitted, because I do work with a lot of law students and law graduates awaiting admission, they have to run it by me to make sure that, especially if you're new to the practice area, you want to make sure that if you're signing a stipulation, it's a good stipulation and the client's not going to default, or you're not prejudicing the defendant in any way. Once you feel comfortable as a volunteer doing it, we will have you start meeting with the client and conducting the intake with the client, speaking with opposing counsel, arguing with or arguing a motion before the court attorney, if that's who the motion's in front of, or the judge. And if you're taking a little bit too long, eventually I will push you into the pool and you'll have to start swimming. So for the most part, people after a couple weeks are comfortable meeting with the client individually, getting information about their case. After an intake, I meet with all of my volunteers in the hallway, and we go over all of our cases for the day. So one by one, so that everyone hears, because every issue is going to be slightly different. We go through every case on a daily basis to find out what's going on and what approach we're going to take. That way, if you get a similar case the next time, you know that's how you handle it. So we never put anyone out there that's not ready to do it on their own. And if they're out there, they have nothing to worry about because there is a safety net, and it's usually the coordinating attorney.
And speaking of the coordinating attorney, what does your program look for in a supervisor for that program? Because it's a pretty unique kind of position. Mm-hmm. I think, the court has partnered with at least 4 different organizations in our Volunteer Lawyer for the Day program. For some of the programs, we've had supervisors, all the way through, but for others, they move on, and I think we've been incredibly lucky with the coordinating attorneys. They've been fabulous, and I just want you to talk a little bit about, what you look for, what they need to do in order to supervise volunteers that have been trained in an area that is relatively new to them. Many of the volunteers are law students or recent law graduates. So if you could give us a little about that. So
it goes without saying, a background in consumer debt, but someone who's willing to mentor and train. A lot of this, I think when the program was created, I think what the court envisioned is the coordinator would be there to coordinate, then volunteers would be doing the work, and we would be there as support for those people and serving as a mentor, a trainer, for those people. So the person that we want in the position is someone who can lead, who can make good legal arguments, who's not afraid to back down. Initially, this was a program that was met with a lot of resistance from plaintiffs' bar, and the relationship that we have with the plaintiffs' bar now is, I would say, amazing compared to what it was in 2009. There was so much contention back in 2009. Now you can go in and it's okay to smile at your opposing counsel or say hello, and it's okay to, it's shocking when you get along with opposing counsel. That's what it should be. Like, this is not a case between you and opposing counsel. You're representing someone, they're representing someone. There's no reason to have any animosity towards each other, and that's changed a lot in Kings County. But being able to, but it doesn't mean you're not going to be met with resistance at times. So you want someone who's going to make the arguments when they need to be made, and you want to push your volunteers, and you want to train your volunteers. You want to make sure that your volunteers understand the laws. If they don't understand why you did why you handled the case a particular way, why did you settle this case and not that case? Being able to explain it to the volunteer, I think, is an important skill to have. Just being there is a strong source of support for your volunteer. I don't know if you want to add anything.
I'll just add briefly. Lori, I think what you said is correct, that it takes a special person. And one thing that is unique about this position in the coordinating attorney is that they're not just supervising people, they're supervising different people on different days with extremely varying levels of skill, maturity, and experience. And that does take a very unique person, and not only to supervise them appropriately and to keep track of what their skills are and to remember it to the, for the next time that they come. If they come once a week, they have to retain that information, but also be managing the court at the same time, managing the calendar call, making sure all the volunteers are in the room or check in or check out if they leave the room, and just dealing with the general chaos of the courtroom. So it really takes a skilled person, and we're so fortunate. Our coordinating attorneys are sitting in the audience. They're probably worrying about their clients that didn't get their assistance this morning. But
I was there.
You were there. Okay.
I went.
Well. But yeah, it takes a unique person and somebody who really loves to mentor and really values that as well.
Anthony, what's been the feedback of the attorneys at your firm about volunteering in the housing program?
So we've had probably in the past 2 years about 40 or 50 attorneys who've participated in the program, and we've been participating, for the past 6 or 7 years, I think. And when you talk to the attorneys who've done it, like I've done kind of before I came here today, I think a lot of them talk about some of the things I mentioned already in terms of making sure providing legal services to those who need it, and the ability to develop their skills as an attorney. But I think the one constant and what really comes through is the feeling that you are leveling the playing field. And I think others on the panel have spoken to this already. And it actually, Yacine, when you were talking about the intake program, it jogged my memory, because I've personally participated in the intake when there's not a case on the docket. And just being down there and meeting with clients who are going to file their answer and just asking them the basic questions as to whether they're Section 8 or rent stabilized, and the types of questions Yacine went through. Oftentimes they have difficulty even understanding those questions, and they don't know the responses to those questions. So, I mean, that you have to take time, review the paperwork, and figure out whether they're fit for the program. But I think that's very telling to the bigger point of how much the representation is needed for them in the system. And so when you talk with the attorneys who have been in the program, that's what really comes through. Because when you meet the clients for the first time, and you're, like Yacine said, you're meeting with them in the hallway on the day they're appearing in court. It's hectic. They're also, sometimes emotional because they do have other things going on, and this could often be the icing on the cake. So they're happy to have you there to tell their story to you, someone who will take the time to listen to them, and someone who's going to be an advocate for them, which is really what they need. And so, I think that aspect of leveling the playing field is really, what comes through on the feedback from the attorneys who participated in the program.
Anthony, does the firm, or did the firm ever have any concerns about conflicts of interest?
Well, conflicts of interest are always a concern at a large law firm. We have, clients in different areas and many different clients. I think, what's unique about the VLFD program, it's limited scope representation. So the conflicts of interest rules provide for that you can go forward with the representation as long as you do not have actual knowledge of a conflict with the volunteer or an attorney in the volunteer's firm. So that, those special rules for limited scope representations help ease the conflicts of interest.
Mm-hmm. Anthony, you also mentioned that many of the litigants you see have difficulty understanding what's going on. So that brings me to the next question. How in your programs, Sidney, Daphne, Yacine, do you make sure to get informed consent about, on the limited retainer agreement? I know you all use limited retainer agreements for your programs, but how do you make sure they understand the scope of the representation? Because it's a little different than advice. You're just sitting there saying, I'm only giving you advice, I'm not representing you. But here, you're actually going in the courtroom with them and representing them on that day. How do you make them understand that that's the only day that you're representing them?
I think you just explained it to them very clearly. We do not appear in any case until we have that signed retainer, and we just repeat and reiterate to the defendant that this is the only day we will be appearing on their case. It is just today. We will not necessarily be there next time. Obviously, if they come back to volunteer lawyer for a day, they can get another volunteer attorney, but we cannot guarantee that, and we make that very clear. And I know that Jenny, our coordinating attorney in Queens, specifically gives them very concrete examples, such she'll say, we are not going to make phone calls on your behalf. We are not going to, address any paperwork that comes to you outside of this room today, this morning. So we just make it very clear. I think people understand that. I think some of the challenges arise when there's a language barrier, which really is a challenge for a number of things. So I think the key is just to make it clear and oftentimes have the defendant repeat it back to you and make sure that they understand that. And we also clarify that when they leave. So we repeat it again when they leave so that they understand. We make sure to answer any questions they have, and we provide them with advice going forward.
Yeah, same here. We just reiterate it, and it's likely that we will assist them in the future, and we provide them with information on how to get someone to help them in the future. So I will send them back to Claro so that they can get a referral. That way, it gives us an opportunity to follow up on any documents they may have received since their last court date. On occasion, there are people who have limited abilities. Like I have a client who speaks only Spanish and she's deaf, and it's impossible for her to communicate on the phone. And that's a situation where she will then come to my office and I will assist her. It won't be through Volunteer Lawyer for the Day. It will be through the VLP. And if she does eventually get sued, she'd come to Claro and get a referral. But the key is to just repeat it. It is in writing. They do get a copy of the retainer agreement. And in the retainer, it says, we're only representing you for this date. It says it's effective on 10/14 and it terminates on that day, 10/14. So we try to make it very clear, and they leave with something in writing that says that as well.
I'm just curious, what percentage of your cases resolve after one court appearance?
I think it's about at least 80%.
The question was, I was curious, when we're talking about a limited retainer agreement, I'm just wondering how many of the cases actually resolve that day where they're going to walk out of court with a resolution of the case. And Daphne, you said 80%?
Yeah, I mean, from what we've gathered from our data, it's about 80%, but that does include, in the definition of resolution, it does include things such as requesting evidence, which maybe in other types of cases does not sound to you like a resolution. And granted, they do have to come back, but in consumer credit cases, that actually is quite a bit of progress, and will expedite the case for future appearances as well. I don't know if your stats are similar.
I would say within 2 court appearances, our cases are resolved. Unless if it's an original creditor who shows up with documentation on the first appearance and we're able to settle the matter on that date, then those get resolved fairly quickly. Generally, with third-party debt buyers, those cases are usually adjourned for additional discovery. So by the second court appearance, those cases are resolved one way or another.
So for each appearance, you would have a new limited notice of appearance, even if it was the same volunteer handling on the second case?
It's this, for both Claro and Volunteer Lawyer for the Day, we have every client sign a retainer or a limited scope representation agreement at every appointment. Clients come in and they're like, I did this last week. Okay, we're gonna do it again. And so we get it every single time. They have to know. I make a speech at the beginning before I hand out the limited scope retainer. Then I hand them the limited scope retainer. They go over it. When they go up to meet with an attorney, the attorney will go over it with them again, and then they will sign it. So it's very clear that this is a limited scope representation, and they have to sign off on it every time they meet with one of our volunteers.
Yacine, this is a court-sponsored program. Do judges handle the VLFD cases any differently than other cases?
Yes, so all of our cases, even though typically both sides are represented by counsel, as I mentioned, landlord's attorneys typically has an attorney, the landlord typically has an attorney, and then we provide a volunteer law graduate or a volunteer attorney to the tenant, and all of these cases that we handle actually go before the judge once there's a stipulation of settlement, and the judge actually allocutes the stipulation. Usually they would be considered a 2-attorney case, and the judge would just so order them, but there's actually an allocution where the judge verifies that our client understands the implications of the agreement or the non-compliance therewith, that they understand, of course, all the terms in the stipulation, and the judge will go over available options in light of their claims and defenses, albeit briefly, and where necessary, the judge will check whether any repairs are warranted, any rent breakdown was provided, and so basically there's really a thorough verification that the stipulation passes muster.
And this question is for all of you. Has there been any, could you give an example of a scenario where your program faced an ethical, or not even an ethical, a difficult situation with a client, how you handled it?
So Kevin Thomas, who is our coordinating attorney in the Bronx, when I asked him this question, one of the things that he mentioned that happens pretty often is there will be a defendant who doesn't want to, is taking time off work to come to this court appearance, and doesn't recognize the debt, is disputing the debt, but yet does not want to take more time off of work to come into court. And so they don't understand their rights before they speak with one of our volunteer attorneys. And they are more amenable than perhaps they should be to entering into a settlement just to be done. They're scared, they don't want to come back, they're losing money that they need, take time off work. And we are, Kevin mentioned this, he's faced with the difficult task of obviously advocating for what your client wants, and yet explaining to them what their rights are, and that if they do something as simple as request discovery, that there is a good chance that the case may be dismissed, or perhaps it's a case of even identity theft. And so I think, the resolution to that, it differs. Sometimes we will get defendants that literally are this scared of coming to court or really need the money and don't understand what it's about and just think it's going to be over if they sign a settlement agreement. And so in that case, what we can do is, the best we can do for them is to make sure the settlement is fair as it can be. And if not, we just try to explain to them again their rights and encourage them to consider coming back one additional time to see if the matter resolves.
Yeah, I would think something similar along the lines, or just at times where clients are feeling that they're being bullied into entering into a settlement based on the way that a court attorney might ask a question. Like, oh, so you just don't want to pay your debts? No, I want verification of my debts before I enter into a settlement. So speaking to the client and making sure that they know what all their options are is extremely important. And sometimes when you take the time to explain to a client, this is what the plaintiff has to do. The burden is on them. The burden is not on you to show that you don't owe the debt. If you have proof that you don't owe this debt, by all means, bring it in. That's extremely helpful. But the burden is on the plaintiff to prove the debt. These are your options. You're dealing with a third-party debt buyer. You can settle today. You'll probably get a decent settlement, payment plan that you can afford, and you can go home and never come back today. Option 2, demand discovery. They have to provide you with everything they intend to present at trial within 45 or 60 days. Once you get those, you come to me. I'll look at them at Claro and let you know what your defenses are to those documents. Do they have enough to prove their case here? Or 3, if the case is down for trial, do you want to go to trial, proceed at trial? We're not going to represent you at trial. We can prep you at trial. It's important to, from an ethical perspective, to make sure that your client is aware of all of their options, because things happen so quickly in the personal appearance, in the pro se part. And sometimes you're running around when you have 10 cases and 5 volunteers and you're trying to figure out what's going on. Sometimes you might forget to sit down and tell your client, okay, these are your options. What do you want to do? Because sometimes they don't understand. Today we had a case where the gentleman was being sued for $3,700. It was an original creditor. He's only receiving Social Security. He's in no position to settle, no position whatsoever. It was down for trial. They wanted to proceed to trial. We have no defenses. They have their contract. They have everything that they need to prove their case. What do? The judge's hands are tied at this point. You can't force someone to settle. The only thing that the judge can do is go to trial. You get a judgment, and it's a judgment that's not collectible. And so at the last minute, plaintiff said, you know what, let's sell this for $500. So from $3,700 to $500, $10 a month, starting in 3 months. And so that sounded like a great deal to me, excellent deal to me. But my client still didn't understand it. And he's like, to him, $10 was a lot of money. And it was, because his Social Security check didn't cover his rent. So how is he going to pay the $10? His wife is on disability. The credit card, if you look at it, was used to pay Con Ed. And so he's paying his utilities on this credit card. So what do you do in this situation? So at which point he had other debts. We talked briefly about bankruptcy as an option. So that's one thing. We handle bankruptcies in our office, so I'm able to speak to them about bankruptcy as an option. And possibly just doing a confession of judgment for today, calling my office, we'll set you up with an attorney for bankruptcy, and go from there. His wife seemed to understand a lot more, but she's not a party to this case. So she went back and she sat down with him and said, this was a good deal that they offered you, $500, $10 a month, starting in 3 months. He still has the bankruptcy option, There's plenty of time to meet and consult with the bankruptcy attorney if he needs to do that. In the meantime, he would leave court without a judgment on his credit report. So when we went back out and we sat down with him and explained what had happened and explained to him that there was no interest on this $500, because he kept thinking, and then there's interest and it's going to keep adding up and I'm never going to stop paying it. And you explain those things to him. Then he understood it and said, you know what, I'm going to do the $500. Starting in January, I'll start to pay $10 a month. In the meantime, if he does bankruptcy, perfect. It gets resolved, but he left today without a judgment and a settlement that's very reasonable, only because we were able to sit back down outside with him or in the back of the courtroom and explain exactly what happened. And you have that duty to your client to do that, to make sure they know all of their options, good and bad.
Challenging case. I do recall a matter where we had a client who owed about close to $20,000 in rent arrears, and he said that he had a circle of friends and family members who could help him pay that debt, and we had noticed that a large chunk of the arrears was older than a year, so we had raised the defense of laches, and we wanted to get the old rent severed so that he wouldn't be liable for a judgment in housing court, and it would lessen the risk that he would get evicted in the event that he had difficulty honoring any stipulation. Opposing counsel was was not in favor of settling the matter by severing part of the rent arrears, even though we thought we had a good case. You can't twist someone's arm in a settlement context. You have to both agree to mutually to the outcome. So the client was convinced that he could get his circle to pay up, but we felt that it was too much money. It was too risky. As you know, he lived in a rent-stabilized apartment. It was too important for him to hold on to that apartment. And I think he was a freelancer, so the likelihood that he would get a one-shot deal from the Department of Social Services was slim to none. We really didn't feel comfortable entering into a stipulation exposing him to that level of risk. So we decided that we would ask for to go up before the judge and expose the facts and see what the judge would say. And we were very happy that the judge on her own said she would feel uncomfortable so ordering any stipulation of settlement, providing for that tenant to enter into a payment schedule to pay about $20,000 over the course of a few months. And that gave us at least time to adjourn the case, continue negotiating, and it gave also the client an opportunity to go back to his circle and figure out whether or not they were good for the money.
Thank you. We have about 1.5 minutes for questions. Does anyone have any questions for the panel? Yeah.
I have a question. If there's an unrepresented litigant in BLFD and they don't speak English and wait to get a translator, how do you use the translator as far as you talking to your client about the case in an attorney-client relationship?
I didn't hear part of the question. What do you
do when your client
Yeah.
does not speak English?
Yeah.
You inform the court and get a translator, but you have that translator be there when you're discussing the facts of the case.
So we
Repeat the
have.
question.
Okay. The question was, what do you do when you have a client whose first language is not English and you have to communicate with them in their native language. We do have control over the types of cases we can take. So in the past, we've had coordinating attorneys who were bilingual or trilingual, and we were able to pick up Spanish-speaking. Well, we can't. Because we conduct intake, we pick and choose the cases where we can actually communicate with our clients. If we figure that there is language barrier, then we can get a hold of court interpreters, and they can assist with interpreting in the hallways. And any client or any litigant who has language barrier in court can request a free court interpreter, and they will go over the terms of the stipulation. They would go before the judge when the judge addresses them, or they would go before the court attorney.
And to be more specific, the court interpreter can assist the VLFD attorney in communicating with the client. It's a court interpreter who is pursuant to court rules, also in a confidential setting, because they can't disclose it. All right, it to a certain degree, certain languages, the litigants may be at a disadvantage because we may not have at ready disposable, the interpreter on that day. But in Spanish and Chinese and Creole French, Russian, Polish, we have interpreters that are employed by the court. We always have them. So if you speak a language other than that, when you come for intake, we may not be able to take the case because we may not have a per diem interpreter in that, like Bengalese or something like that. But on the court appearance, we can get an interpreter. Okay. Yes?
One other question. If at VLFD, your client's ready to enter into some kind of settlement and there's a stipulation, do you as the VLFD attorneys sign the stipulation or just have the client sign it?
We have both the client and the attorney, the person representing the client, sign the stipulation. And of course, the adversary.
In consumer debt, the attorney does not sign the stipulation, just the litigant.
Well, that needs to be looked at.
Okay, because we have a different practice. Okay, we will talk about that. Anyway, you'll learn something new every day. I think the attorney should be signing it, Sidney. Okay, because it's a limited appearance. You should be signing it. Anyway, we see? Okay. Nope. And we'll fix that. Okay, we're not perfect, all right? Because it signifies that the attorney assisted with that particular stipulation. It does not bind the attorney for future appearances because we have a limited appearance, okay?